Hello, my name is Gary Frischling, and I'm pleased to introduce the fourth lecture in the Continuing Legal Education series sponsored by American Friends of the Hebrew University in partnership with the American Association of Jewish Lawyers and Jurists. Today's topic, International Human Rights Law and the Fight Against Online Antisemitism, is presented by Professor Yuval Sheny, holder of the Hirsch Lauterbach Chair in Public International Law at the Hebrew University, as well as a researcher at the Israel Democracy Institute and former member of the UN Human Rights Committee. With a background in international human rights law, international criminal law, and internet regulation, Professor Sheny has the expertise needed for an extensive overview of the legal and policy-making challenges posed by the battle against online antisemitism. International law and internet regulation are among the many fields of study that can be found at the Hebrew University of Jerusalem Faculty of Law. The Faculty of Law is Israel's premier institution of legal education, the alma mater of numerous Supreme Court justices, attorneys general, Knesset members, senior government officials, and leaders of Israel's legal profession. Located at the university's Mount Scopus campus, the Faculty of Law was established in 1949 as the first law faculty at any Israeli university. The Faculty of Law has earned an international reputation for excellence, ranking 30th in the 2021 Shanghai ranking of law schools and ranking first among Israeli law schools. The Shanghai ranking consultancy has also ranked the Hebrew University of Jerusalem 90th in its 2021 academic ranking of world universities, which translates to Hebrew University being among the top 5% of universities around the world, as well as the leading university in Israel. American Friends of Hebrew University is proud to bring this lecture series to you as part of our ongoing effort to spotlight and support the academic excellence, cutting-edge research, and dynamic innovation that the Hebrew University provides in service to the State of Israel and people throughout the world. And finally, for those who are seeking continuing legal education credit, there will be a CLE code announced during the presentation. Please make a note of it, and you'll receive by email post-event evaluation materials. And with that, let me please turn it over to Professor Sheny.
Thank you very much, Gary, and thank you for joining this meeting. I'll share the screen. Just a second. Okay, so my presentation is titled International Human Rights Law and the Fight Against Online Antisemitism. This is a topic which, as indicated, does build up on my work, both at the university, where I direct the legal part of the Federman Cybersecurity Research Center, which is an interdisciplinary research center that focuses on regulating cyberspace, regulating internet services, and regulating digital technology. And it also builds on my work at the UN, working on the application of international human rights law standards in a variety of jurisdictions around the world, including the US, Israel, and many other countries. And also, it builds on a project I've been involved in recent years with the Israel Democracy Institute and Yad Vashem, which generated a series of policy recommendations for internet intermediary or online platforms that is aimed at improving their content regulation policies in the face of online hate speech. There has been a vast literature and media and other attention which had been directed towards the problem of hate speech, online hate speech. Of course, hate speech is not a problem that is unique to the online domain, to the internet and other online platforms. But it does appear to have a particularly serious, several particularly serious dimensions when transposed from the offline world into the online world. And that include the scale, scope, and speed of dissemination of offensive contents, which is unparalleled online when compared to other forms of, or more traditional forms of dissemination. And the concern here is that the this method of pattern of dissemination could lead very quickly to very serious real-life consequences. And I think people have become much more concerned and much more attuned to this problem following the 2017 massacres in Myanmar, Burma, directed against the Rohingya minority, and fueled and facilitated by extensive use of Facebook as a way to recruit essentially genociders. Another oft-cited concern about online hate speech is that online hate speech often builds on existing echo chambers and filter bubbles that do tend to amplify and reverberate within closed groups, or at least intellectually or ideologically closed groups, thus having a more serious repercussions than in the offline world. At the same time, when looking at the other side of the problem, and that is the problem of regulation, it has been commented that regulation of online speech and online hate speech is particularly difficult, given the fact that we are often expecting that global companies would regulate speech in many different jurisdictions around the world, which have very different cultural, political, and linguistic domestic contexts, which the companies and their employees are struggling to understand and to effectively regulate from a distance. And this concern really builds on the other two elements, bullet points that you see here on the slide, and that is that states who have traditionally taken a lead role in regulating hate speech are quite a marginal actor in the world of online hate speech. And the emphasis and the center of gravity in regulating online speech migrates to private companies that are effectively expected to employ regulatory powers that traditionally were held by governments. Now, online hate speech is, of course, a serious problem across the board. It also, of course, is a serious problem, and maybe a particularly serious problem when one is dealing with anti-Semitism, because I think anti-Semitism is not just one particular type of hate speech, like all others. I think it also builds on certain features which are accentuated by an online environment, which is basically building on pre-existing patterns of animosity, which is something that algorithms know well how to identify and to amplify. We are seeing concerns across the board about the use of conspiracy theories in online messaging, and anti-Semitism is an arena where there has been extensive use of conspiracy theories as part of the messaging. And hate speech is particularly serious when it results in re-victimization of past victims of hate speech and hate action. And again, anti-Semitism is a form of hate speech which often involves re-victimization of past victims. So in terms of the different forms of hate speech, anti-Semitism usually is considered as one of the most serious forms of hate speech. And we tend to see a resurgence of this speech, like other hate speeches, when one is dealing with societal problems such as crisis, the one that we're currently seeing, a political populism, and when this is enmeshed in international conflicts, such as the Middle East conflict that is often related or is being portrayed in terms which are often anti-Semitic. So on the one hand, we are seeing a very serious and perhaps a growingly serious problem, social problem, which is the use of of hate speech on online platforms. The problem becomes even more acute when one considers traditional reluctance of online platforms to regulate hate speech. This is encapsulated by Mark Zuckerberg's very famous quote that Facebook shouldn't be the arbiter of truth. This is the traditional hands-off policy that Facebook and some of the other platforms have embraced pretty much up until recently. And this reluctance has many roots and many explanations. But I would argue that from a lawyer's perspective, this is perhaps augmented by the cultural pull of the First Amendment in the United States, the fact that many of the major companies are US-based companies, which are very much, have been very much raised in the First Amendment culture. I think this is part of the explanation why these companies are quite reluctant to apply powers of censorship, although of course the First Amendment applies to government agencies and not to private agencies. It does apply a considerable cultural pull in that direction. I think the culture of the internet is also one which is featured by what is called net neutrality. This is again a principle that does not directly apply to content, to internet intermediary or to online platforms. Typically something that is attached to internet service providers, but the same kind of idea, the same kind of hands-off of treating all data packets that migrate across the net similarly without any form of discrimination, I think also colors the way in which content moderators are approaching different types of speech. In the United States, we do have an additional element which encourages this hands-off approach, and this is the famous or infamous Section 230 of the Communications Decency Act, which is a legal provision that generates immunity for content for internet intermediaries or online platforms against being sued for civil wrongs, for most civil wrongs that are hosting offense. So you do have in place also a law that doesn't generate legal consequences from placing hate or offensive comments on the platforms, barring a few exceptions. And also, I should say, the international framework that I will immediately expand upon does also view with some degree of reluctance attempts by governments to serve as arbiters of truth and to penalize individuals for expressing opinions that are historically erroneous. So what are called sometimes memory laws, which are criminal provisions in a number of countries' laws that penalize expressions such as Holocaust denial, Armenian genocide denial, but in other countries, other historical events such as in Russia, this may have to do with the Great Patriotic War and the official narrative concerning that war. In Poland, this could be the involvement of Poland in the Holocaust. I mean, these memory laws are generally viewed from an international human rights law as somewhat problematic. So I think it's this ecosystem which perhaps pushed companies that are in the business of hosting contents to adopt this no arbiter of truth approach, this hands-off approach, and not regard content moderation as a significant part of their business model or social responsibility. Now, the international human rights framework, which I have alluded to, I think is very important here for our discussion. because it does represent global standards. And global standards are important because they basically provide a certain baseline against which one can evaluate attempts by states to interfere with freedom of expression, and also to try to overregulate internet companies that are in the business of content moderation or are potentially in the business of content moderation. I think they're also important for the companies themselves, because they provide, certainly companies that operate on a global scale, it would be very difficult for them to adjust their policies in a very radical way when they move from one country to another. It's very hard. Sometimes it's not even clear to which direction they are subject. The contents themselves move from one jurisdiction from another, the users, their servers. But as a practical matter, what almost all of these companies, the big companies, resort to is a uniform set of community standards that are applied in different countries with some modest variations and modifications. And for these companies, I think it is important to identify a set of more or less universal standards that would provide them some comfort that what actually providing is, generally speaking, within the boundaries of accepted norms of moderation or of expression, expression regulation. And the relevant standard here, which is, I think, the most important two sets of provisions that are found in international law that governs freedom of expression, is Article 19 of the International Covenant on Civil and Political Rights, which is a treaty that binds 173 countries around the world. Most of the major countries in which the major companies operate are bound by this treaty. One major exception to what I've just said is China, which is not bound by this treaty. It has not joined this treaty. But as we know, many of the large companies do not operate in China and do not subject themselves to Chinese requirements concerning content moderation. What this covenant provides in Article 19 is that there is a right to freedom of expression. That right is articulated in quite broad terms as covering all forms of expression in all forms of media. However, there are two limitations which are very important to acknowledge with regard to this provision. First, Article 19, Part 3 does allow states to introduce legal limitations on freedom of expression for very specific reasons. It can be for respect of the rights or reputations of others. So, for instance, defamation laws would typically be covered by this provision, and certain hate speech provisions could be viewed as a sort of either individual or group defamation issue, right, to raise group or individual defamation issues. And the second provision is protection of national security, public order, public health, or morals, and this could justify certain security-related censorship in some countries, or, for instance, restrictions on publication of information which contains disinformation, which has some public health repercussions, such as relating to COVID-19, etc. So these would be typically areas in which states may introduce limitations, and by extension, I think it would be fair to say that the companies could also introduce certain content moderations that would be kosher under international law if they fall within the Article 19.3 exceptions. And then you have Article 20, which is even more radical in its approach. And this is, I should say, something that the United States has taken exception of when it joined the ICCPR, indicating that it will not go beyond the First Amendment. Article 20 does require states, as opposed to Article 19.3 that allows states. Article 20 actually requires states to ban by law propaganda of war, which is less relevant for our purposes, but Article 20, paragraph 2 does deal with any advocacy of national, racial, or religious hatred that constitute incitement to discrimination, hostility, or violence shall be prohibited by law. And hate speech, which is directed against a religious group and facilitates discrimination, hostility, or violence, therefore must be outlawed by domestic legislation. Antisemitism typically fall under Article 20, paragraph 2, and that would imply that would have to ban such speech, and that the companies operating within such states would equally have to basically implement these bans in their content moderation policies. Now, the importance of the international law framework is that it actually provides a framework for governmental regulation, but as I already indicated, it also provides a framework to self-regulation, to the manner in which the companies themselves develop and implement their community standards. And what we have seen in the last 4 years in particular, following the growing backlash against the prevalent hate speech, anti-Semitic hate speech and other hate speech on online platforms, is a pincer movement directed at enhancing content moderation, online content moderation. And we are seeing this both in the ways in which governments increasingly attempt to regulate the companies, but also in the ways in which the companies themselves respond to these attempted regulations. So on the government side, we have been hearing in recent years in the United States, politicians, actually on both sides of the political aisle, discussing the need to review Section 230 and consider removing the immunity from claims, from tort claims, which is currently available to the major to the companies. But in other countries, we are seeing already steps in this direction. So Germany has passed 3 years ago quite a drastic law. It's called the German Network Enforcement Act, that does require companies to promptly remove unlawful contents from their platforms upon being notified that unlawful content is on their platforms. And if they do not remove expeditiously such contents, they would be subject to considerable civil fines. We are now seeing an attempt to introduce such a system across the European Union in draft legislation that is called Digital Services Act. I should say that even in Israel, where there is currently an attempt to pass legislation that would authorize district court judges to order companies to remove from the platform's content which is unlawful and constitutes a threat to personal or public safety. And we also see within states an increasing use of what are called internet referral units, which are government agencies that are basically identifying unlawful contents online platforms, and are submitting official requests to the platforms to remove such contents from their services. At the same time, we have seen companies revise quite extensively their terms of use and community standards, which are in a way their principal self-regulation tools. And two examples of this, we have seen about a year ago, Facebook announcing a new policy on Holocaust denial, basically reversing course on the arbiters of truth position and accepting that Holocaust denial is a form of hate speech, which would be outlawed in Facebook. And Twitter has taken about the same time a new policy turn with regard to misleading information. So we have seen the companies take a more aggressive and more interventionist approach vis-a-vis certain contents, which is particularly offensive or socially unacceptable. So this is for the CLE credits. I'm continuing. So what does international law actually mean for content moderation decisions in cases involving online hate speech and anti-Semitic hate speech, which I will shortly expand upon more? It means, as I've said before, that states have to basically adjust the regulatory policies in line with these standards. And that the platforms themselves would be directed against adopting themselves these sort of standards as a form of a safe harbor, in a sense of a form of a safe space that would give them some assurance against extensive state regulation which is excessive, but also would keep them out of trouble vis-a-vis their clients, their users, though they would be able to invoke what are internationally acceptable standards of contents. Now, with regard to states, perhaps it is important to know that under human rights law, states are not only required to take negative, so to speak, measures, namely they're not only expected to refrain from introducing censorship vis-a-vis speech, they are also required at times to take active measures in order to ensure that international standards are being applied. And that would mean, in the context of Article 20, which I alluded to before, of the International Covenant on Civil and Political Rights, that states would actually be expected to pressurize those entities within their territory that are complicit in disseminating hate speech. So in this regard, states would be actually expected to regulate the contents, regulate the conduct of internet intermediaries or online platforms that allow hate speech to be hosted on their platforms. And maybe it's important to acknowledge in this respect that this is not and I will go back to this in a couple of minutes, this is not a position that should be seen necessarily as a position that is hostile to freedom of expression. The idea that you have to actually remove hate speech. I think there's something that was issued a few years ago by the Canadian Supreme Court, in a case called Watcott, that basically stipulated that hate speech is not, restrictions on hate speech are actually a way in which one can facilitate free speech. Because if you create, if you basically create an environment, a speech environment, which is filled of hate, this actually operates as a chilling factor, as a manner which actually crowds out other speech, and basically prevents other speech generators from participating in the discourse. So A speech environment, which is a hateful speech environment, is not a speech environment in which conditions for freedom of expression could actually be reasonably realized. So I think there is here a philosophical issue lurking in the background, is whether regulation of speech is bad for freedom of expression, or under certain conditions actually conducive to freedom of expression. Going forward, we are already hearing calls that, the current configuration that we have, that is regulation, some international regulation of states, which trickles down to regulation of platforms and maybe create some incentives for platforms to regulate themselves, would be gradually substituted by the development of international standards that would apply directly to technology companies. And there have already been some notable voices within the human rights system. The slides here does provide a quote from Professor David Kay from Irvine, California, who was the UN Special Rapporteur for Freedom of Expression for 6 years, and was actually a very vocal advocate for placing international obligations directly on internet companies. And I think that this vision of regulating directly the companies sits quite well with the increased appreciation of at least the major companies as entities that apply government-like power, in the sense that they basically determine the extent in which individuals in society have a voice and have the ability to actually take part meaningfully in public affairs. And in that regard, we are seeing a process also of internalization of this status and the attendant responsibilities that come with this status by the companies themselves. And one perhaps important development in that regard has been the establishment of the Facebook Oversight Board about a year ago, where you basically have, this has been colloquially referred to as the Facebook Supreme Court. You basically have a body of 20, eventually there will be 40 decision makers that basically sit on appeal on borderline decisions to remove contents or to keep contents on the platform. And this is, I think, part of the move towards some rule of law and due process standards that the companies would eventually be expected to provide the users. Now, when we are looking at the companies as lawmakers, as I said before, we do have the terms of use and the community rules as the main regulatory instruments that basically provide the policies of the companies. And if you look at the Facebook company rules on hate speech, and I'm using Facebook because it's probably still the most important actor in this field, and the actor that has probably given the most attention to these legal issues, we do see quite an elaborate definition of what constitutes hate speech, and as a result would be subject to content moderation on the platform. This is quite for the lawyers in the room, this is quite an interesting way to define a legal text, a legal notion. It does have this a little bit of informal and example-driven feature. But when you think about this, is this a good definition, and would it cover effectively anti-Semitic speech? The truth is that this is actually a very problematic definition. Although I should say it's constantly being in the process of being revised. The last revision was last November. For instance, it does use idiosyncratic language as to what constitutes hate speech, which is built around protecting what are protected groups and the definition does offer a closed list, a limited list of protected groups. So it doesn't cover all forms of hate speech. It covers some forms of hate speech, which are direct and are aimed at specific groups. So obviously this does not cover indirect attacks, and it does not cover all groups. So for instance, political groups, socioeconomic groups are not covered. And as we will see, other groups are not covered. And it also tends to basically divide the world of content moderation into different silos. So there is one silo that is dealing with hate speech, another silo dealing with violent speech, another silo that is dealing with disinformation. I think one of the problems with modern hate speech, and especially with anti-Semitic hate speech, is that you actually have elements of all three of these silos in anti-Semitic speech, and the policies do not actually reflect adequately the fact that you have here a combination of problematic or prohibited forms of speech. So the definition tends to be under-inclusive, the one that is used by Facebook, which is by extension also true for other platforms. And at the same time, you could also argue that in some respects it is over-inclusive, in the sense that it may cover speech that you would not want to actually moderate. I think at the more abstract level, what you could say about the structure that you have in place is that it does seem to project a false choice between censorship and freedom of expression, in the sense that you have basically the default position is everything goes, and then you have a reason, you need special reasons to take off certain contents. But the truth of the matter is that a lot of the problem that we are seeing are not problems which are related to content moderation. They're really content of social media design, namely that you have algorithms that do tend to amplify certain speech, which generates a lot of traffic. And this is almost by definition, controversial speech would be speech that would generate a lot of traffic. And these are issues that you could actually address without going into the mode of striking away contents, but you could actually address them by changing the way in which the algorithm is designed. I would also say about this, the current system that we have is we have these definitions which are quite detailed, but still ultimately contain considerable discretion on the part of the content moderators. We are seeing the companies increasingly rely on algorithms to perform content moderation. But at this point in time, we know that the algorithms still have limited ability to identify in close calls, to identify sarcasm, to identify humor, to identify insinuation. So we have a system which is imperfect in terms of the definition, highly imperfect or flawed in terms of the definitions that it uses, but also the actual technology and the system that it has in place is also flawed. When you speak specifically about anti-Semitism, I think what we are seeing, as I indicated before, all of the problems that I noted before about the policies do, I think, come to life with regard to anti-Semitic speech. For instance, anti-Semitic speech often involves proxies, such as use of Zionists instead of Jews, which under the at least the common reading, or perhaps the way in which traditionally the policies have been read by the platforms would not cover these sort of proxy attacks. So if you do not use the term Jews, but you use another term which could serve as a proxy, it's not clear whether the policy would be applied. Although I know that the companies are constantly updating the use of proxies. as I said before, the policy does not, up until now, the policy has not been sufficiently sensitive to historical patterns in terms of hate speech, and specifically anti-Semitism has not combined between hate speech and conspiracy theories and disinformation, and more generally has not internalized international standards that apply, important international standards that apply in this field, should apply in this field, and these are the Rabat Plan of Action standards that have been developed under the aegis of the UN, and basically point in content moderation decisions not only to the content, but also to the to other elements such as the context of the statement used, the speaker's position or status, the specific intent, the extent of dissemination, the likelihood of harm. So the policies that we currently have in place address some elements of offensive speech and dangerous speech, but do not cover others. As I said in the beginning of my presentation, I've been involved in recent years in a project that was co-sponsored by the Israel Democracy Institute and the Yad Vashem Institute that basically assembled a group of experts from around the world, including American experts, European experts, Israeli experts, including experts that have basically that have had the UN experience and UN functions. And we were trying basically to see how we can, what recommendations we can make to online companies, internet companies, to improve their hate speech policies, with a view inter alia to have better policies that would address anti-Semitic speech. And the main policy recommendations that I can note, and with this I will conclude my presentation, is that first, our first recommendation is that we consider social media companies as legally and ethically responsible for the harm which is caused by their platforms. So the hands-off approach is unacceptable, that the definitions should be harmonized with international standards, and they should take into account aggravating factors such as patterns of hate, problems of re-victimization, and problems regarding to disinformation and conspiracy, that the regulation of hate speech, or more generally content moderation, should not be binary in nature. It's not an on-off removal or non-removal. These are not the only choices. As I said before, dealing with the algorithms in ways which would slow down the dissemination of hate speech is as important as engaging in removal. There is also more that the companies could do preemptively in order to alert users that they may be violating when uploading contents, company rules in terms of use. There have been also recommendations about making complaint procedures and flagging mechanisms more accessible to users. And finally, there has been a call on companies to engage in broader efforts to engage stakeholders, including civic societies, in developing and applying their hate speech policies. So this is the second CLE code word that with which I will conclude, and I now look forward to hearing questions and any remarks members of the audience may have.
Sure. So thank you so much, Professor Shani, for that great presentation. We do have a bunch of questions. The first one is, has any group been successful in fighting hate and its members, and what can we learn from it?
This is a difficult question because it doesn't require a definition of success. I think we have seen the rules that have been periodically updated in ways that introduce more and more groups For instance, persons with disabilities have been, I think, able to get noticed by the platforms, and to basically get specific rules and specific examples in the guidelines that would apply to them the hate speech regulations. I think with regard to anti-Semitism, I would consider the reversal of course on Holocaust denial as actually a great success on the part of groups such as the ADL, who were arguing against this policy and actually pressurizing Facebook with an advertiser's ban until the policy would be removed. So there have been some success stories, and I think they have to do with mobilization of groups and advocates on the part of the group, and creation of coalitions between consumer groups and civil society groups that are fighting hate speech and discrimination. Perhaps we are also seeing, to some extent, the fact that we are seeing increased political pressure on the major platforms coming from different directions, both from in terms of their speech, content moderation policies, but also in terms of other aspects of their business practices. It has also created a shift in the way the major companies are applying policies on issues such as disinformation, calls for violence. So I think it's certainly not, they're certainly not above being pressurized by civil society and by consumer groups.
Thank you. Are there any enforcement mechanisms in place for non-compliance? If so, are there any examples that have been utilized?
So as I said before, in Europe, we do have within domestic legislation of a number of countries, most significantly Germany, but we've also seen in France legislation in that direction, and also the EU is going in that direction. There have been basically laws that require companies to vigorously apply content moderation policies and remove rapidly content which is offensive and unlawful. This could, when I say rapidly, it could be in certain cases involving, for instance, terrorism, 1 hour. And there could be significant multi-million euro fines on companies that do not comply with removal requests, and these norms are enforceable in the sense that the companies have presence in these countries, they have assets in these countries, and they have already been subject to fines by these countries in a number of other policy areas. So you do have in countries where there is no immunity on the one hand, and there is specific legislation that requires companies to apply more robust content removal policies. Yes, it will be quite effective, and I think that part of the reason why the companies are reviewing their content moderation policies is the pressure from these laws. I should know that these laws, from a human rights point of view, are problematic, because although one could make the case that unlawful content should be removed, especially if it also constitutes a form of hate speech. The concern here is that the very creation of an obligation based on flagging could create a chilling effect for the companies, and in borderline cases, they would rather remove and not take the risk of being fined than keep fighting to keep the contents on. So I think we are still struggling to find a proper point of equilibrium between the legitimate interest of governments to basically remove, to facilitate the removal of online hate speech, and the companies' lax policies in this regard.
Why are statements that Israel should not exist, or other statements like that, not actionable? Is it too broad, or is it just an opinion without being a threat espoused for any particular action?
Yeah, so in terms of so the way that currently the community rules are formulated is you first have to identify what is the relevant silo in which you are dealing with. So probably the comment you've just made would not violate the violence silo. Because it's like you said, in terms of calls for violence, it doesn't appear to be like something which creates a clear and present danger or a specific call for violence. The question would be whether this is a form of anti-Semitic speech, and you know that the IRA, the International Holocaust Remembers Alliance definition for anti-Semitism does introduce also anti-Israeli statements that single out Israel or does not, or deny that the Jews have a right to self-determination. They do include this under the rubric of hate speech. The companies so far have not endorsed fully the IRA definition. If they were to endorse the IRA definition, then it could be at least be, you could make the argument that a statement like this would qualify as a form of hate speech, but this is not currently the policies that they embrace.
Can you talk a little bit about the UN's role and how these anti-Semitic statements are implemented? And is there sort of a clear policy, or is it dependent on the country?
So in terms of a UN role, I mean, the UN does not regulate the companies themselves by and large. The UN does regulate states. I mean, it does review the way in which states uphold their human rights standards. And it can exact sometimes pressure on states to do more in the field of hate speech. So for instance, when I was at the UN Human Rights Committee, we were reviewing, for instance, the way in which a country like Netherlands dealt with mostly Islamophobic speech by senior politicians in that country. And through that review, there could be eventually some indirect pressure on the companies. I'm not aware of any specific case in which the UN has criticized the country for not applying pressure on the UN did not criticize a state for not applying pressure on a company, but I do think that in the future we will see more of that kind of chain reaction taking place.
Have you seen any instances of, instead of closing down offensive websites, requiring platform companies to open them up to the public and notify activist organizations to counteract the offensive narrative that's being put out there?
So I haven't seen this in the form of regulation. I know there is a growing interest in counter speech, in actually developing models that would not actually I think there is a general concern that content moderation, to the extent that it results in binary remove or not remove decisions, could actually lead to problematic consequences, and that as a result, one has to apply some other less aggressive forms of regulation, especially for what could be considered as borderline contents, which is offensive, but the freedom covers offensive speech to the extent that it does not cross a line into inciting hatred, violence, or discrimination. So in that context, you could say that counter speech is increasingly regarded as a promising avenue, such as limits on virality that slow down the dissemination of offensive speech, and also some soft mechanisms such as basically advising content disseminators to reconsider the content, so reminding them about the terms of use or community regulations. But I haven't seen yet governments actually require opening up to counter messaging. I think this is an interesting avenue, but so far I haven't seen this actually put in practice.
Okay, I believe that was the last question.
So that's great. I mean, thank you very much for your time and interest. And back to you, Gary.
And thank you, Professor Shaney, and to all the participants, and Happy New Year to everyone. All the participants will be receiving an email tomorrow with a link to the evaluation, and please complete that, and then you'll receive your CLE credits. The next program in this series is February 2nd, 2022. It's a Wednesday. The title is Heuristics and Biases in Court Decision Making, and it's going to be featuring Professor Doron Teichmann. For future programs and to learn more about these programs, please visit www.afhu.org. And I wish everybody a wonderful rest of the day.